set up for tonight's video. We're going to be looking at a field of study that I'm really not super familiar with, so I hope you guys will bear with me as we walk through this together. I'm not a legal expert, you might have noticed. I don't have a JD or anything like that. I don't know if you guys can hear me. Hopefully you can now that I've got my mic. I think what we hope to get today is kind of to figure out what exactly this bill says that calls itself the Respect for Marriage Act. I suspect it does not deliver what it says it will. I'd be surprised if it did. I don't know if you guys recall, but the Inflation Reduction Act did literally the opposite of what it was supposed to do. So we're going to take a peek at this different bill and see what it says. And then we're going to also look at a couple different cases about this concept, specifically the Masterpiece Cake Shop case and the case of this lady who doesn't want to design websites for people with different sexual orientations. Website designer, Colorado. Let me see if I can find this story. Yep, okay, so we have from Colorado Public Radio. Okay, well, let's dive into it. We're just going to be reading straight from the text of the bill, so no shenanigans here. You can see this is congress.gov, 117th Congress. Fascinating. Yes, indeed, patch a like button. Thank you, Soundwave. He's moderator. I will pin that for sure. All right, let's read it. In the Senate of the United States, November 29th, 2022, resolved that the bill from the House of Representatives, H.R. 8404, entitled An Act to Repeal the Defense of Marriage Act and ensure respect for state regulation of marriage and for other purposes, do pass with the following. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the Respect for Marriage Act. All right. Findings. Congress finds the following. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. Interesting that they mention family. Diverse beliefs about the role of gender in marriage are held by reasonable and sincere people based on decent and honorable religious or philosophical premises. Therefore, Congress affirms that such people and their diverse beliefs are due proper respect. Okay, so far so good. Millions of people, including interracial and same-sex couples, have entered into marriage and have enjoyed the rights and privileges associated with marriage. Couples joining in marriage deserve to have the dignity, stability, and ongoing protection that marriage affords to families and children. Repeal of section added to... Okay, this is just like housekeeping stuff. Section 1738C of Title 28 United States Code is repealed. So this is in a response to the Defense of Marriage Act, which I think we should probably look at too, but we'll do that later. In general, no person acting under color of state law may deny full faith and credit to any public act, record, or judicial proceeding of any other state pertaining to a marriage between two individuals on the basis of sex, race, ethnicity, or national origin of those individuals. So, no person acting under color of state law. I'm not sure what exactly that entails. We'll have to check that out, what it means to be acting under color of state law. A right or claim arising from such a marriage on the basis that such marriage would not be recognized under the law of that state on the basis of the sex, race, ethnicity, or national origin of the individuals. Enforcement by Attorney General. The Attorney General may bring a civil action in the appropriate United States District Court against any person who violates subsection A for the declaratory and injunctive relief. Private right of action. Any person who is harmed by a violation of subsection A may bring a civil action in the appropriate United States District Court against a person who violated such subsection for declaratory and injunctive relief. Any person who is, anyone who's harmed by the violation of subsection A. A says that you can't discriminate against someone and their marriage if you're working alongside the state on the basis of gender, sex, religion, race, etc. Okay. So this is like definitional stuff. I don't know if you guys have ever actually read a bill. This one isn't very long and we're going to get through the whole thing. But there's a lot of housekeeping stuff in here. It's like Section 7 of Title I, United States Code is amended to read as follows. 7. Marriage. A. For the purpose of any federal law, rule, or regulation in which marital status is a factor, an individual shall be considered married if that person's marriage is between two individuals and is valid in the state where the marriage was entered into, or in the case of a marriage entered into outside any state, if the marriage is between two individuals and is valid in the place where entered into, and the marriage could have been entered into in a state. In this section, the term state means a state, the District of Columbia, the Commonwealth of Puerto Rico, or any other territory or possession of the United States. For purposes of subsection A, in determining whether a marriage is valid in the state or the place where entered into, if outside of any state, only the law of the jurisdiction applies at the time of marriage was entered into may be considered. Oh, okay. So they're going to be very specific here. No impact on religious liberty and conscience. In general, nothing in this act or any amendment made by this act shall be construed to diminish or abrogate a religious party, liberty, or conscience protection otherwise available to an individual organization under the Constitution of the United States or federal law. Goods or services. Consistent with the First Amendment to the Constitution, nonprofit religious organizations, including churches, mosques, synagogues, temples, non-denominational ministries, interdenominational and ecumenical organizations, mission organizations, faith-based social agencies, religious education institutions, and nonprofit entities whose principal purpose is the study, practice, or advancement of religion, and any employee of such an organization shall not be required to provide services, accommodate, advantages, facilities, goods, or privileges for the solemnization or celebration of a marriage. Any refusal under this subsection to provide such services, accommodation, advantages, facilities, goods, or privileges shall not create any civil claim or cause of action. Okay, you might think that's great. That gives a kind of out for people who are working in religious organizations, but I am here to challenge that assumption, because let's consider for a moment what a religious person does in a day that is not Sunday. If you are a religious person like, for example, Jack Phillips, I think is his name, and you work in your own little business called Masterpiece Cake Shop in Denver, Colorado, just for example, apropos of nothing, and you are a Christian 24/7, even when you're not at church. When a gay couple comes up to you and says, you will make this cake for us or else, and you offer them a different kind of cake that's not personalized to their specific marriage because it goes against your religious code, and they say that's not good enough, you have to bake the cake, bigot, and then they drag you into court repeatedly, racking up your legal fees to an unending degree, I don't think that this does not solve that problem. All this does is say if you are actually in a religious function, if you are in a religious institution, if you work for one of those institutions, then you cannot be forced to accommodate this. That's great. That's fine. But what about a religious person who's just working? Now, this gets right into the artistic expression stuff, which is very nebulous, at least at this point. So we're going to look at a couple different instances. We're going to look at Neil Gorsuch talking about the Colorado case. Neil Gorsuch accuses Colorado of forcing a Christian baker to undergo a re-education program. Interesting. Let's see what he has to say. Justice Gorsuch slammed the state of Colorado on Monday for forcing a Christian baker to undergo a, quote, re-education program after he refused to create a custom cake celebrating a same-sex marriage on the grounds that it violated his religious convictions. The comment came during an opening argument before the Supreme Court on a case involving a Christian web designer who said she would refuse to produce a personalized website advertising a same-sex wedding if a client came to her seeking such a site. In 2018, the court handed a narrow victory to cake artist Jack Phillips and Masterpiece Cake Shop, ruling that the Colorado Civil Rights Commission acted with unusual religious animus in 2012 when it ordered Phillips and his staff to receive anti-discrimination training. However, the decision did not make a major judgment on the compelled speech issue at the heart of the case, which the court is finally expected to address in the 303 Creative case currently before it. 303 Creative is the company owned by the woman who says she would prefer not to create a web page for a same-sex couple if they ask her to do so. This is kind of a preemptive blow. Mr. Phillips had to go through a re-education training program, did he not? Gorsuch asked Colorado Solicitor General Eric Olson. He retorted that it was actually training to educate him about the Colorado law. Some would call that a re-education program, Gorsuch said. I strongly disagree, the defense attorney replied. Isn't religious belief a protected characteristic? Gorsuch asked, to which Olson conceded yes. Phillips' punishment from the Colorado Commission also included a requirement that he submit quarterly reports on his company's compliance progress. On Monday, Kristen Wagner, the Alliance Defending Freedom attorney representing Christian website designer Lori Smith, noted that because Colorado's aggressive enforcement, her client's speech has been chilled for 6 years. Colorado argued that Smith's website creation qualifies as a public accommodation, binding her to serve every member of the community. That is insane to me. If you create something, if you want to design web pages and suddenly you are offering a public commodity that must be accessible to every single person, regardless of your personal religious beliefs, that's mind-boggling. The defense, even if it offends her conscience. The defense drew a connection between opposition to interracial marriage and opposition to same-sex marriage, arguing that a ruling in Smith's favor could set a precedent under which vendors could refuse service based on race. Yes, absolutely. Good point. Wagner contended that Smith's websites are customized to fit each individual customer and include an expressive message. Regardless of how ambiguous and general the format and information presented on the sites, a pro-same-sex marriage message would be embedded in a site made for a gay couple, she argued. Artists like Smith should not be coerced to curate a product for a same-sex marriage, but selling a pre-existing product off the shelf is different, Wagner clarified. This is exactly the argument that Jack Phillips made in the Masterpiece Cake Shop. He offered this couple a different, non-customized cake for their enjoyment, and they turned him down. They wanted him to customize it. They wanted him to violate his conscience because they wanted a case. I still haven't determined exactly why they decided to do that, but not only did they go after him for this, they also went after him for not wanting to make a transgender gender reassignment celebration cake. They literally went back to his shop and they're like, you're going to make this transgender cake or else you're going back to court. And of course he said no, and they took him back to court. It's absolutely crazy, and that's something that I feel like people don't exactly engage with. That's something that should be considered for sure. This man was clearly targeted. And I feel like this web designer is taking more proactive action, which I respect, given what else is happening in Colorado. Excuse me. But I think that what happened with Jack Phillips is absolutely crazy. And it's going to happen more often because we have chosen to involve the government in every aspect of our lives. We've chosen to create human rights commissions. I didn't even realize that Colorado had one until this happened. I think that we are expecting them in Canada and places like that, but 100% not in the US. Certainly not in Colorado, where I'm from. Although I will say, during the time that my husband was also there, we noticed that everybody was coming over from California and they were voting very California values. And what was happening was that Denver was turning into a kind of San Francisco East. It was a serious issue. There was a huge deal of homelessness. Rent was skyrocketing. It was crazy towns. But that's exactly what happened in Denver. And it is what we can expect in the rest of the country if we allow this kind of stuff to get through. Let's continue reading about this case. Wagner contended that Smith's websites are customized. Okay, we already read that. Artists like Smith should not be coerced to curate a product for same-sex marriages, but selling okay. The compelled speech doctrine no longer applies once you've entered the product into a stream of commerce. I'm not sure what that means. What you're saying is, I want to give gay couples a limited menu, Justice Sotomayor retorted. Probed by, yeah, that's correct. Because if somebody has a religious conviction, if somebody comes in and they're like, oh, I'm a Satanist, are you going to bake me a Satan-oriented cake? Probably not. The answer should 100% be no, and you should have the right to say that. I don't think that cake or websites are a public commodity that everyone is entitled to. In fact, I think the best solution to this kind of nonsense is if someone does make a discriminatory business practice when it comes to, for example, selling a cake to an interracial company, couple. I think what should happen is that another shop should open up across the street that promptly puts them out of business as the free market intended. Because it doesn't make sense to me to force someone to do something that is inconsistent with their personal beliefs just to make some kind of point about what exactly. This seems to me like such a virtue signal and such a serious diversity, equity, and inclusion front. And it's only going to get worse because this passed, and I think that Republicans are too weak to stand up against it, too afraid of being called racist or homophobic. Probed by Justice Amy Coney Barrett, Wagner surmised that her client would reject requests to publish sites that include content contradicting her strongly held religious beliefs, possibly including sites designed for a formerly divorced couple or a couple indifferent to the meaning of marriage. It's not about sexuality, it's about the message, Wagner declared. Very interesting. So that case is going to be super interesting. They're arguing that one in front of the Supreme Court, I believe, today. Justice Gorsuch made a very good point about actual re-education programs taking place for the Colorado baker. Let's look at this one from the Cato Institute, which I believe is more libertarian-oriented. This is from today. What is the issue in the Supreme Court's web designer case, and why do so many people misstate it? All right, people who should know better, who surely do know better, keep misstating the legal issue in the cases brought by individual creators who don't want to be forced to create cakes, floral arrangements, photography, or websites for same-sex weddings. The question in Monday's argument before the Supreme Court, as the court defined it, was whether applying a public accommodation law to compel an artist to speak or stay silent, contrary to the artist's sincerely held religious belief, violates the free speech or free exercise clauses of the First Amendment. That is, the issue is compelled speech. That's fair analysis. But distinguished legal scholars and journalists keep misstating the cases as whether a service provider can refuse service to certain types of people, such as gay people. For instance, in the New York Times, David Cole, who taught for 26 years at Georgetown Law School before becoming a national legal director of the ACLU, writes, the right question is whether someone who chooses to open a business to the public should have the right to turn away gay customers. But Lori Smith doesn't want to turn away gay customers. She only wants to decline requests to create websites for gay weddings. She says she happily serves LGBTQ customers who come to her for other sorts of websites. In the Los Angeles Times, Erwin Chemerinsky, dean of the UC Berkeley Law School, says Smith will be in violation of a Colorado law that prohibits businesses that sell or offer services to the public from discriminating based on disability, race, creed, color, sex, sexual orientation, marital status, national origin, or ancestry. But again, Smith doesn't want to discriminate against any person. She just doesn't want to design websites that promote what she sees as offensive ideas. Presumably, she would turn down a straight man who wanted her to create a website for a same-sex wedding of his friends. Fair analysis. In the Washington Post, Robert Barnes connects Smith's case to that of another Coloradan, Jack Phillips of Masterpiece Cake Shop, who several years ago declined to create a cake celebrating a gay wedding. A wedding which, by the way, had been held in Massachusetts because the state of Colorado refused to allow gay people to get married at the time. Barnes notes that Phillips is currently in new litigation over his refusal to create a cake for a transgender customer. That's right, I mentioned that earlier. But that again is wrong. There's no evidence that Phillips would refuse to create a cake for a transgender person. He did decline to create a cake that celebrates a gender transition. In all these cases, the issue is whether being required to use your creative abilities to celebrate an event that you regard as immoral constitutes compelled speech under current law. The distinction between refusing to serve gay customers and refusing to participate in a particular celebration requested by a gay customer may not be obvious to lay people, but it's an important distinction and one that is not obscure to legal scholars and journalists. They should state the position of the bakers, website designers, and other creators accurately. Well, that's a very fair analysis. I respect that from the Cato Institute for sure. And I appreciate that distinction as well. I think that's fair to say that we need to recognize that they have no ill will toward people who are, for example, homosexual, for people who are transgender, anything like that. They simply do not want to be forced to do something that requires them to violate their own conscience. And honestly, I am just kind of at my wit's end as far as the U.S. is concerned if this is something that they can hammer through. This is a serious issue. I don't like this idea that people can just be forced to do something that violates their conscience. How can a Christian be at peace with the understanding that they were forced to do something that they completely disagree with. But I repeat myself, I think that probably the best solution to all of this would be a stronger Republican Party that was able to stand up and say no to this. But everyone is too afraid to stick up for what they actually believe. They don't like the idea of being singled out. They don't like the idea of being called names. But I don't think that this is something that's I don't think this is worth being concerned about that for. I think people need to focus on what they truly believe and push forward. Let's read one last article and then I'll wrap it because I am beat today. My apologies. Not high energy, very low energy. The Supreme Court seems poised to side with Colorado web designer in 303 creative case. Okay, interesting. Justices heard arguments on Monday that will test whether Colorado's public accommodations law, which bans businesses from discriminating against LGBTQ customers, can have exceptions based on the type of business it is. The case, 303 Creative versus Elenis, pits a Colorado website designer named Lori Smith against state officials trying to enforce Colorado's Anti-Discrimination Act. Smith wants to start creating custom wedding websites. Specifically, she wants to post a message on her company's site that she would not create websites for same-sex marriages or any other marriage that is not between one man and one woman, according to a brief in the case. But state officials would consider that discriminatory behavior based on the state's laws, so Smith sued the state. On Monday, in 2.5 hours of debate, the justices seemed poised to rule that creative businesses would be protected by the First Amendment and stands apart from, say, hotels or bus companies. Right. This is completely different from a restaurant that refuses to serve like an interracial couple or a gay couple. They seem to acknowledge that a state should not be allowed to completely compel a creative business to speak a message it doesn't believe. That's a great point, too, because so much of creative work is about speech and about conveying these different ideas. This is definitely something that bears consideration, especially when Colorado is being so authoritarian about forcing people to do and not do certain things. Basically compelled speech, which is exactly what Jordan Peterson was up against in Canada. The oral arguments come at a time when Colorado is still reeling from a mass shooting at an LGBTQ nightclub. All right, that has nothing to do with that. Even Justice Elena Kagan, who is among the more liberal members of the court, told Colorado Solicitor General Eric Olson, who argued on behalf of the state, that she had a hard time picturing how a state could require, hypothetically, a web designer like Smith to create all kinds of wedding websites. Kagan made the argument that if it was a plug-and-play website where everything was standard and there was no creative component to it, Smith would likely have to sell that website to anyone who asked for it. But then she acknowledged it could get more dicey. A gay couple walks in and says, "I'd like the standard website, everything's standard, but I want something in addition to that. I want the homepage to say, God blesses this union." And Miss Smith says this is a problem. I don't know. I think that is kind of different. Also acknowledge that. Where you have direct speech, it does get trickier. Yeah, duh, because we have the First Amendment. This is not something you can compel someone to do. But Justice Ketanji Brown Jackson tried to raise the specter of the slippery slope nature of this case by posing another hypothetical story in front of the lawyers on both sides. A photographer in a mall wants to take old-timey photos of Christmas scenes from the 1940s and 50s, and in those scenes, he only wants to take photos of the white children and not kids of color. Would that photographer be allowed to do that? And that's a good question. Smith's lawyer, Kristen Wagner from the Alliance Defending Freedom, said she didn't think that case represented a message. It represented the status of someone who was trying to buy a good or service. It is the objection they're asserting part of the message, Wagner said. I can say that when there is an overlap between message and status, message does win. Justice Neil Gorsuch tried to pick apart Olson's argument that a press release writer or a freelance speechwriter could have more protections than a business like Smith's. This individual will create all manner of websites, just not one that requires her to write words on a page that celebrates a particular thing that she finds offends her religious beliefs. When she has said, "I will not sell to anyone a message that I disagree with as a manner of my religious faith," just as the speechwriter says, or the freelance writer says, "I will not sell to anyone a speech that offends my religious beliefs." And then they refer back to the 2017 case, Lakewood Bakery called Masterpiece Cake Shop. Oh, I didn't realize it was in Lakewood. Lakewood Bakery called Masterpiece Cake Shop against a gay couple in Denver who asked for a custom wedding cake and was denied. The court declined to definitively answer the question at hand, though, so many legal experts say the justices took up the 303 creative case to come to some resolution once and for all. Okay, that's fair too. I just don't find that this particular act does at all what it says it does. I don't think it promotes actual respect for marriage. I think it creates deeper divides. I think it deepens the divisions that we already have between religious people and people in the LGBTQ community, for example. Although, as stated by the Cato Institute, it is not the people with whom these bakers, for example, and website designers have an issue. It is simply, for example, the state of marriage. It is simply the entire concept behind what they're being asked to do. It's not the people themselves. They hold no ill will toward them. This is in no way like discriminatory, race-based, allowance, whether you can use a water fountain. This is very much a case of, oh, I appreciate you. You're another fellow human being, but you're promoting an idea that I cannot get on board with. And because I am a creative person, I choose not to embrace that. I choose not to make this site. You will have to find another designer. And I think that just as customers should be allowed, just as customers do go from one merchant to another, designers should also be able to give them a referral to another place that will, for example, accommodate them. In fact, one of the things that they could say would be, you know what, if you're not going to make this cake for this gay couple, if you're not going to make this website for this gay couple's marriage, then what you can do and what you should do instead is give them a referral to someone who will, or offer them the basic, like Jack Phillips attempted to do in the Masterpiece Cake Shop case. But I digress. This, as I said before, is out of my wheelhouse. I'm not a legal scholar, and I'm very low energy this evening, so I apologize. Tomorrow we are going to record a Making the Argument about this that will be released on Thursday. So we'll really get into all the details of the case, and we'll talk about what it means for marriage and why. Well, we'll kind of analyze exactly the implications that it might have for traditional marriage going forward. I personally have such a great issue with trying to redefine marriage at such a late hour. I recall when Obama was first elected, he was not on board with gay marriage at all, which was kind of interesting. But then just a few years later, he changed his mind. And now everyone kind of assumes that you will be fine with it, even though people do, in fact, hold religious beliefs that kind of preclude it from them. Like, it's not something they're okay with. And that does not mean that they hate the people involved. It simply means that they can't condone their lifestyle. But again, I digress. I think that this will have interesting fallout. I will add too, this is something that I forgot to pull up, but Fox News pointed out that they declined a religious exemption, respect for marriage act. Let me see if I can pull this up real fast. We'll at least read the opening part. Where's my Fox News article? I know I had it just a minute ago. Dumb. All right, there we go. Oh, well, here we go. Here we have an opinion from Senator Mike Lee, just in closing. Respect for Marriage Act, why religious liberty deserves protection and how my amendment will provide it. Yeah, Mike Lee tried to offer an amendment to the act that would specifically protect religious liberty. So let's see what Mike Lee's contained, and then we'll close. Recently, Respect for Marriage Act, a bill designed to protect same-sex marriage by essentially codifying the Supreme Court's 2015 ruling in Obergefell v. Hodges, cleared a major procedural hurdle and appears to be on fast track to becoming law. 12 Senate Republicans joined all 50 Senate Democrats to secure the supermajority needed to advance legislation in the Senate. This is what I'm talking about, a weak Republican Party. Those voting for the bill relied on assurances from the bill's proponents that it would codify the core tenets of Obergefell versus Hodges without undermining religious liberty. While the tension between same-sex marriage and religious liberty might not be obvious to many, legal experts have long understood that there is a legitimate risk that without robust protections in place, federal recognition of same-sex marriage could, read against the backdrop of various federal statutes and the way they have been interpreted by the Supreme Court, inflict harm on those who, for reasons rooted in sincerely held religious belief or moral convictions, do not embrace same-sex marriage. One potential manifestation of this risk was highlighted in a now famous exchange between Justice Samuel Alito and then Solicitor General Donald Verrilli at the time Obergefell was argued in 2015, in which Verrilli correctly and repeatedly acknowledged that once same-sex marriage is recognized nationwide, many colleges, universities, and other nonprofits could lose their tax-exempt status based on their refusal, rooted in religious belief, to recognize same-sex marriage. While many senators, particularly Republicans, with many senators aware of this and other concerns, The Act's leading proponents amended the bill by adding protections for religious service attendance and the solemnization of marriage, but those protections are inadequate to address many of the gravest risks posed by this bill, particularly those threatening the tax-exempt status of religious nonprofits. Fortunately, there's still time to amend the bill. Okay, so Democrats shot these amendments down. They did not want religious exemptions for people who are simply religious people out in the workforce. And that to me is the clearest indicator that this is not going to be about respecting marriage. This is going to be about more postmodern goalpost shifting to try to get conservatives into the leftist wheelhouse by hook or by crook in some form of authoritarianism, and this just looks like more bad news to me. Although I could be wrong, I've been wrong in the past, but I'm also a good judge of character, and when I suspect something like this is the case, it often is, unfortunately. So I hope I'm wrong. I really do. Today's supposed to be Good News Tuesday. Unfortunately, I promised that I would cover this on my evening live stream, so I am doing that here. I know we have more news out of Twitter. I might cover that in my live stream tomorrow. We'll see what happens. Until then, let's see here. I will see you all next time. I appreciate your time. Oh, let me see if I have any super chats before I leave. I do not. None tonight. No worries. Very low energy. Understandable. All right, guys. Thank you very much for tuning in. I very much appreciate it. And I will see you all tomorrow. Until next time. Bye, guys.